the court this afternoon is the case entitled In Re Petition of Rutland Renewable Energy, LLC, for Certificate of Public Good pursuant to 30 VSA Section 248 et al. Versus Town of Rutland, Joseph Romeo, Charles Flanders, Ted Hubbard, Robert Cara Jr., trustee of Robert Cara Trust, and David Fucci. Representing the appellant, Town of Rutland, is Kevin Brown. Seated at council table with Mr. Brown and representing the neighbors is Alan George. Representing the appellee is Kimberly Hayden. Seated at council table with Ms. Hayden is Danielle Chingala.
Okay, have we got an agreement on your side, Mr. George, as to splitting up time? Are you taking the whole 15 minutes? What's the arrangement?
I'm going to take 5 minutes and then yield to my co-counsel.
Okay.
And I will save some time for rebuttal.
And that's, of course, up to you, but I want to make sure because we're in this courtroom, we don't have our ordinary lights. We're dependent upon signs from afar.
And I'm told I'll have a sign after 5 minutes.
You'll have a sign after 5 minutes, okay. All right. That's
better organized than perhaps the court would expect.
That's not the case at all. I just want to make sure I understand what you're doing, that's all. Okay, please go ahead.
Good afternoon, may it please the court. The case has been one that's been on the Public Service Board docket and on appeal for quite a long time. I know that's frustrating to the petitioner in the case, represented by Ms. Hayden. But nevertheless, here we are. And here I am with a bit of laryngitis that's chronic to me in these advanced years. So please, I hope you can hear me and understand me. Section 248 of Title 30 has as its purpose resolution of a single issue, whether or not a particular project under Section 248's jurisdictional authority will advance the public interest. Nobody disagrees with this in this case. Everyone agrees that that's the purpose of the statute, and this court has held that in the Vandell case and other cases cited in my brief, and I'm sure in other briefs. One of the issues, however, is how do you actually apply and interpret that standard? And I want to go to the criteria regarding the impact of a project on aesthetics. Section 248 from the very beginning, when it was enacted in 1969 as initially Section 246, specifically contained a provision that a project, in order to be qualified for a certificate of public good, must not have an undue effect, adverse effect, on aesthetics. In those days, aesthetics was spelled with an E, not with an A. But
can I just, I know I'm interrupting, but it's something that will help me here, and maybe you can't answer it. All of us had to get here some way, so I came down Route 7, and just south of Virgins is a very large solar field. Is the one we're talking about here larger than the one I observed?
I'm not sure.
The same size, or do you not know?
This project will be as large as any in the state so far. I know the governor.
15 acres, right?
It's going to be in excess of 10,000 panels on 15 acres of a 22-acre parcel. That parcel, at 22 acres, also contains wetlands. Virtually all of the area that can be developed will be developed here. And it will be a 2.2 megawatt facility. And I don't think there's one larger than that in the state right now. I know last week the governor indicated that very large facilities beyond 4 times this size we should not be permitted, but that was a political position. So I can't be very particular.
All right, I just was trying to fix it in my mind so I could understand the aesthetic argument.
It's a significant project, and actually in our printed case, you have quite a bit of information about the project, its size, and even some photography involving the site at the very end of the printed case in an expert witness's report. Perhaps the most important thing I want to communicate here is that Section 248 has always required a finding that there is not an undue adverse effect on aesthetics or on historic sites or on the natural environment. That's been there from the very beginning. Judge Gibson, when I started practicing, Ernest Gibson III was chairman of the Public Service Board. And I can tell you anecdotally that I'd go out on cases with him, as did Joe Frank, who was the counsel for the board at that time, and the board and the commission at that time. There was no division of authority between the Public Service Board and the Department of Public Services.
I'm sorry, I know that your time's running short, and so I want to make sure I get your sense of this. The need to have a finding of no undue adverse impact has been there all along. As I understand it, the critical issue in this case is where do you stand when you're assessing the adverse impact? And do you only stand on public land, or do you also stand on private property? Can you, in 30 seconds or something, answer me?
Yes, I can. The board takes the view that they only look from public land. They concede, and I quote them in my brief, that they deviate to that extent from Act 250 review panels, district commissions, and the environmental court, formerly the environmental board. There's no reason in the world why the board members and their staff can't go on a site of a private property and determine whether or not this project is, in Quechua language, shocking. There is absolutely no reason why that can't be done. I think I've got to yield. I hardly got anything said.
All right,
You said
I'll
that.
have a chance to come back.
thank you.
I'll try to be quick to reserve some time. It is the court, Kevin Brown here for the town of Rutland. And I want to point out, this is a really important case to the town. We have Don Chaffee, one of the select persons, Mary Ashcroft, one of the select persons, and Tom Terenzini, our state representative, who were so concerned by this case and the treatment that the PSB rendered to the town's standards that it prepared specifically for PSB Section 248 proceedings. That petition went out, the town spearheaded the petition, over 40 other towns signed on because the PSB...
But Mr. Brown, we're not a political body.
I
We're
understand.
interpreting the statute. Obviously, some of this concern got reflected in an amendment to the statute that wasn't applicable when the petition was signed here. So I'm having trouble understanding how I should react to what you just said.
What I was about to say is that what's happened since validates the concerns expressed in our brief about what happened here. The town isn't making this up. The process is broken, and the legislature's now.
But showed there is a correction device
Right.
in the legislature,
Correct.
and so it isn't our power or responsibility to correct a statute that isn't giving adequate voice to the town's concern, is it?
That's correct. I agree with that, but it is your role to correct injustice when it occurs here by virtue of the application of the rules that the PSB uses and has used historically to basically negate opposition to solar projects.
So can I ask, just to try to get to what I see as the heart, at least, of the orderly development issue, is that the statute requires that the PSB give due consideration to the planning commission and other things. And that language actually is in the new corrected version of the statute as well. What does that mean? Does that mean read it and then do whatever you want with it? Does that
No.
mean it actually has some
No, it's-
power?
No, exactly. Due consideration has to mean review in good faith. And and hear the concerns. And
Wait a minute, your allegation is that they did it in bad faith?
yes, I detailed 5.
No, you detailed how ways you disagree with it. Bad faith?
Yes. Given the application of the rules by the PSB, they're listed in the brief, how they handled it here, to get rid of, to be able to ignore the town's solar standards. First, they said, well, it's in conflict with the 2009 general standard. It's not. It's a specific standard developed subsequently. The PSB faulted the town for not addressing other impacts of potential other impacts of other developments on prime ag soils and such. When this standard that was prepared in the third year of the town plan's life was addressed specifically for PSB proceedings, for section 248 proceedings.
Let me go back to the statutory language, because, and you got some of this question from Justice Robinson, but I'm going to go to another part of it, which is that B1 standard will not unduly interfere with the orderly development of the region.
Correct.
And so isn't the question the region, and the region is bigger than the town? I'm not sure, and maybe you can help me as to understand what the region is.
Well, that's a bit unclear, Justice Stilley. We argued below, when the evidence was presented below, that the region was the general area, and I think region has to slide.
Less than a town?
Yes. If you're looking at a statewide project, a power line that goes through several counties, sure, the region's going to be bigger. But when you're looking at a solar projects of this type that Section 248 now is dealing with regularly, then you've got to look more narrowly. So,
Except it refers to, with due consideration, that's what Justice Robinson asked you about, the recommendation of the municipal and regional planning commissions and the recommendation of the municipal legislative bodies.
Right.
Doesn't that suggest that it's not just one town? The S's there indicate more than one town?
it might, well, again, 248 is designed for all types of PSB projects, including ones that span the state. I think I should pause and hope that there's a little bit of time left.
All right, thank you. Counsel?
Good afternoon.
Good afternoon.
My name is Kimberly Hayden, and I represent Rutland Renewable Energy, the appellee. The Rutland Renewable Energy Project is a 2.3 megawatt solar project. It will comprise about 15 acres of land when it's built. It's similar in size to the 2.2 megawatt solar project that this board, that this court considered in In-Ray cross-pollination. The site to that is 2012 Vermont 29. That project was right off of Route 7 in the town of New Haven. There are some controlling, I believe, statements from the court in connection with that project that apply here as well, concerning the standard of review. Are you able to hear me?
Mm-hmm.
Yes.
Okay. So the project, when the board considers these 248 petitions, it's engaged in a legislative policymaking process. The court on appeal presumes that the decisions that the board makes are correct and rationally derived from the evidence. And the court has applied the same deferential standard in numerous 248 appeals.
So let me ask that, because one of the challenges here isn't exactly the evidence doesn't support. It's this notion that the act requires due consideration, and the claim is that the town and all the various bodies presented a whole bunch of evidence, and then the board came in and completely twisted it around to get to the outcome that they wanted, and that can't be due consideration. So I'm going to ask you the same question I asked Mr. Brown, which is, does due consideration just mean show us that you read it, or does it actually mean give it some bite in your decision-making process?
Well, due consideration, this court has held, postulates that the action, for example, the standards that the town developed are advisory rather than controlling. Due consideration is a clause that applies in both 248B5, which deals with the aesthetics criterion, as well as 248B1, the orderly development criterion. When the due consideration clause was considered by this court in the seminal decision of City of South Burlington versus Vermont Electric Power in 1975, the court found that that clause meant that zoning enactments by a municipality are preempted. In other words,
Would you say that again, please?
the court found in City of South Burlington versus Vermont Electric Power, 133 Vermont 438, 1975 decision, which interpreted what due consideration means, that local zoning is preempted.
So, I'm sorry, but just if the, rather than doing this sort of reinterpretation that the town argues happened here, if the PSB had said, okay, we've looked at the siding plan done by the town, and we've considered it, but frankly, we reject it in its entirety, and we conclude that this project satisfies the criteria of being in the public good. Don't attempt to distinguish it or reinterpret it, just say we reject it. Is that due consideration or not?
I don't think that would have been due consideration, but I can tell you that's not what happened here. And so let me just recite a couple of facts in terms of the process and then some of the board's findings under due consideration, both as to B5 and as to B1. This was a 15-month process. There were 3 site visits. The third one the board itself attended following oral argument. There were 4 days of technical hearings. And the board heard testimony from numerous witnesses. There's well over 1,000 pages of testimony and exhibits in the record that the board relied upon. Their order is over 100 pages in length and over 250 separate detailed findings, mostly under the orderly development and the aesthetics issues, because those were the contested issues. Under the orderly development issue, there was also the town had challenged the appellant for not having properly addressed agricultural soils on the site, which were addressed in the town's standards as well. The board considered all of that evidence. As to orderly development, they said that some of their consideration was the fact that the site itself was designated by the town as industrial, that the town plan had 3 energy objectives, one of which related to advancement of renewable energy, that at the time of the technical hearings, the standards were under amendment and had not been revised. And so with respect to the orderly development criterion, I think the board in its order, it's very clear from its order, considered many other factors that they found to conflict with the solar siting standards. At the end of the day, their determination, I believe, was that the standards were de facto zoning.
One of the ways the board kind of responded also to the standards was, to the argument about part of the standards, now I'm talking about the setbacks, was if you, the neighbors, as I understand it, argued that the proper thing to do was to impose the setbacks, so the project would become smaller. The board said, no, the answer is that's not the project, and therefore we can't do that. I was surprised, I must admit, at that answer. Isn't it possible for the board to say, no, the size is variable, depending upon all the other criteria we're evaluating it by. And of course, we can decide that it can't be that size for aesthetic reasons or some of the other reasons that are involved. There's no reason why the size couldn't be reduced. Why can't the board do that?
You know, in my view, I think they could have done that. I'm not aware of a case where they have ruled that its size of a project needs to be smaller. But I think that what their decision on that point was focused on the aesthetics of the project, and very important there, all 3 aesthetic consultants, including the consultant for the landowners, agreed that the project was not shocking or offensive in terms of its views. That
I mean, that really goes to the other issue, right? They agreed that if you stand on public land, it's not shocking or offensive. But I've read your cases on this issue, and I see a long history of board decisions where we say we're not going to take the subjective sensibilities of somebody who happens to live next to the project and evaluating whether it's shocking or offensive. But I'm trying to figure out when the transition to the rule that you're advocating here and that the board took here, which is we're not even going to stand on the property owned by a private landowner and from an objective perspective ask the question whether this is shocking and offensive. We don't care about the private landowner.
Well, and I don't think the board said we don't care about the private landowner. I think the board relied on the expert report of the landowner's aesthetic consultant, who found that it was not shocking and offensive.
From the road.
It's not clear from her report covers the views from private property. The board's public site visit covered, they certainly visited all of the surrounding residences. And significantly from her, and this is the landowner's aesthetic consultant, her report, she said there were things that influenced her determination that this was not shocking and offensive, including the fact that these are low profile. These panels are about 12 feet in height at their maximum. That the property, there were a lack of identified scenic resources or valued open space on this parcel of land. She also factored into to her consideration that it was designated as industrial commercial, and therefore the town had left open the potential that this site could have been developed. And then the board certainly spoke about this as well, with some other commercial development that would have a much higher profile impact than did this solar project. I think in its order on reconsideration, the board also, because this was the hearing officer's decision was challenged, and then the board, its final ruling was challenged. On the order on reconsideration, the board said that the mitigation that the developer proposed, which included 528 shrubs and 72 trees to screen these.
So if I'm hearing you right, to the extent that the PSP said that the expert opinions were all based on an analysis of public views from Cold River and Stratton roads, and that this approach is consistent with longstanding board precedent regarding who constitutes an average person for purposes of this analysis, you're not ruling out the possibility that the experts could have said, oh, but by the way, from the perspective of this private parcel next to the thing, it is shocking and offensive, and here's why, and that would have been cognizable by the PSP as a factor.
The board has consistently held that the average person is not the landowner who's adjacent to a project, and I think that is appropriate. They rely on the INRAE Bandel decision, Vermont Electric Power, versus Bandel, and in this court's recent INRAE Singular Wireless decision, 2012 Vermont 46, the court has said, and the board relies on this, that the sole issue in a 248 proceeding is what's in the public interest, and so particularized interests of adjoining landowners are not the concern in a 248 proceeding. Certainly the legislature could change that, but that it has been the basis for the board's review and the lens that it applies when it's conducting a 248 assessment for any project, including a solar project. I think importantly too, under 248b1, recently the legislation was amended to require the board to give due consideration to greenhouse gas impacts. And that legislation requires the board to consider the societal benefits of the project from a climate change perspective as well. And so if individual towns or adjoining landowners are able to preclude a project because of its aesthetic impact, having considered everything else that comprises that project, including the fact that the purpose of these projects is to reduce greenhouse gases in the state of Vermont as part of our policy, then I think that we're not going to achieve that policy. So the board has, I would argue in this case, they probably did rigidly apply that. I don't know, I do think that they factored individual landowner views because they did conduct a site visit from those views, and they spoke specifically to that in terms of the mitigation.
Let me go back to the new legislation. So I'm looking at the provision in B1, and that's 1B, that's now required and not applicable to your project. Do you meet them? There's a screening requirements of municipal bylaw adopted on 24 VSA 44-14-15. Do you meet the screening requirements in their policy at this point?
I'm not aware that there were specific landscape screening requirements in the solar siting standards.
But the 2291-28, that's the setback, and you don't meet them. There's no
the
question.
setback. There's no question that I think this project is about 60 feet setback from the road. The solar siting standards had a 500-foot setback for.
Okay, what I was really going to is the ladder outs for those, which if the new ones requiring such compliance would prohibit or have effect of prohibiting the installation of such facility or have the effect of interfering with the facility's intended functional use. Would you say that you would have met those, and therefore, even under the new, this project should go forward as planned? I'm trying to understand the language of this statute.
Well, the statute isn't currently, this.
Yeah, I understand that's
and-
fine.
So what you're asking is, would this project be viable at a smaller size? Essentially, it really comes down to that. How many panels can you squeeze on a site and make the finances work so that you can have a power contract that the utility.
Well, it's the wording is intended functional use. Obviously, the functional use is generating solar power from panels, so I don't.
I guess I would argue with that, because I think the functional use is actually being able to build and operate a project that can sell power to Vermont consumers. And so the price of that.
So this is an economics question, whether the size is adequate for your client to make enough money to want to do this? Is that what the point is?
I think it's both. You know, right now the technology is such that these solar projects, the ground mounted at least, are on posts, and there may be technology that'll change that, and we can have less, land space being occupied by these projects, but they are what they are. A certain number of panels are going to take up a certain number of acres. I didn't attend. I don't know what the thinking was in this legislation.
So let me try another one from the statute too, from your side. This is in the old legislation. That is that among the things to be considered are land conservation measures contained in the plan. Now, if the plan here includes the town's separate policy on this subject, wouldn't you view the setback requirements as a land conservation method? We want to not cover every bit of available developable space?
So what the board found with respect to that, and I think they were accurate on the law, was that the land conservation measures have to be specific to the site that's being reviewed. And there was nothing in the siting standards or the town plan that spoke to this specific site.
Well, that would be impossible, would it not?
Actually, I don't think so. Many towns adopt standards that designate areas as scenic and worthy of scenic protection.
That's scenic, but this is land conservation.
Okay, land conservation measures, and that would go to, I apologize, something similar to the agricultural issue that the town has claimed, where they did not designate this area as having agricultural or conservation significance.
Thank you.
I'm not seeing this, I'm sorry.
That's all right. Thank you.
I only have 4 minutes remaining.
All right.
I'm going to try and limit myself to just one of those. First, I want to respond to the notion that the experts somehow decide everything in the case, the aesthetic experts. They're all experienced experts who testify often before the Vermont Public Service Board and know the approach and the criteria that the board applies. I know from my own expert witness, I could not dissuade her to, get her to insist that they're completely wrong. But we consistently wrote that and argued it throughout our case. One of the elements that
But what evidence, I get that you wrote it and argued it through your case, but you also need evidence in the record to support it. Is there any
Yes.
evidence in the record that would support a conclusion that the aesthetics were shocking to an average person if you happen to be standing on the adjoining landowner's property?
Not from the expert witnesses who testified, no.
From anybody else?
Yes, but one of my property owners testified that it was shocking.
To that property owner?
And from the other properties that overlook this project. This project is at the bottom of a valley, and all of these houses look directly on, including 2 historic projects.
And the road did too, no?
And they're on the road as well, yes. I was starting to say before, and I wanted to follow this position, there's no difference really between what is in the public interest and what is in a private interest, generally speaking. Ordinarily, our private interests are also public interests. This apparent argument that there's a conflict there is nonsense. It just doesn't really exist. The Public Service Board, as I was indicating in my original statements, from 1969 forward, had to make these decisions and had to determine whether or not a project met the standard, including the aesthetic impact standard, before it could be approved and granted a certificate of public good. Queechee came in 1985, 15 years later. The Public Service Board eventually adopted some facets of the Queechee standards. But the Queechee standards were never actually imposed in Section 248, although most of the 250 criteria was eventually incorporated in Section 5, but without eliminating the basic requirement that the project not have an adverse impact on aesthetics. The Public Service Board adopted the Queechee standard and then drained it from all of the substance from it, so that it's virtually impossible, and I explain this in my brief. So it's virtually impossible to say that a project is unacceptable from the Public Service Board's perspective because of its aesthetic impact. I want to defer, as I must.
Thank you.
What do we have? Huh?
May
Pardon me?
I have to?
No. Pardon me, I didn't hear you.
35 seconds.
Ah, great. So, I guess in that amount of time, I want to focus quickly on the Queechee analysis. And the PSB has gone down this wrong road, and this is an area where the Supreme Court has a role. By ignoring the effect on the property owners, it's wrong-headed and turns the process into a sham. The court has always been deferential to the PSB with good reason on technical matters and the need for power and how big towers should be, all of that. But your job and role as the court is, it's appropriate to correct the PSB when it applies rules incorrectly. You just did that in the beach case over at Basin Harbor. You had it right. The PSB had it right in the Hellman case, where we looked at under Queechee, would the project defend the sensibilities of the average person faced with a situation similar to the neighbors? The neighbors have a right to be heard on the Queechee analysis.